Welcome to today's program titled Key Issues for Employers Stemming from 2021 EEOC-Initiated Litigation, What 2022 is Apt to Bring. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Jerry Mattman. Jerry, please go ahead.
Thank you so much, and welcome to all of our attendees today for what is one of our most popular annual webinars. We're so pleased that you took time out of your busy schedules to join us. We were speaking before we started that this is about the 17th year that we've hosted the webinar. And if anything is consistent, it's that change is a constant theme when one talks about what's going on with the EEOC. But this is one of our most favorite topics in terms of what's going on in the courthouse, what's going on at the commission, and what that means for employers. And I'm especially pleased and honored today to be joined by three of my colleagues where we will discuss these issues and give you some ideas about planning and what we see on the horizon for the rest of 2022. I am joined by my partners, Chris DeGroff and Matt Gagnon, and our colleague, Sarah Baumann. Sarah will be our discussion leader today. Sarah works with all of us in our complex discrimination litigation department, handles a wide range and gamut of issues for employers, assist employers on a daily basis with EEOC litigation and other types of complex litigation and counseling situations. So Sarah, over to you to kick us off.
Thank you, Jerry. So as Jerry mentioned, I'll be moderating our panel discussion for today. But first, I would just like to introduce my three esteemed colleagues who are experts on the topics we will be discussing. So let's turn to my colleague, Chris, first. Chris DeGroff is the co-chair of the Complex Discrimination Practice Litigation Group and co-chair of Seyfarth's renowned Chicago labor and employment practice. He has spent over 20 years developing a national complex litigation practice with an emphasis on government-initiated cases, especially brought by the EEOC. He has litigated some of the largest EEOC cases in the country and has developed a reputation as a top expert in that area. He is also a frequent author and speaker about these issues and is routinely quoted on matters relating to EEOC and class action litigation. We are very pleased to have him with us today. We are also very pleased to have Matt Gagnon here with us. Matt is also a partner here at Seyfarth, specializing in labor and employment litigation. He has extensive experience counseling and defending clients with a national presence, and his expertise covers the full scope of claims and theories involving allegations of sex, race, age, and pay discrimination, as well as others. Matt is also a frequent author and speaker on these issues, and in particular, he specializes in all things equal pay and is a renowned expert in that area, which has also been a specific area of focus for the EEOC in recent years. So we're very happy to have him with us today and to hear his insight on those topics. And last but certainly not least, we are pleased to be joined by Jerry Mattman today. Jerry is one of the most formidable and well-known employment litigators in the country. He's also a partner in our Chicago and New York offices and co-chair of our Complex Discrimination Litigation Practice Group. 2021 was yet another year of remarkable success for Jerry in courthouses across the country as he defended employers in some of the most sophisticated and high-stakes litigation coast to coast. He's also the principal author of Seyfarth's Workplace Class Action Litigation Report, which has been hailed as the preeminent publication outlining developments in workplace class action litigation. A significant part of Jerry's practice involves litigation against the EEOC, and Jerry has been repeatedly recognized and ranked by almost every publication imaginable for his work, including Chambers, BTI, and Law 360. We're fortunate to have access to his wisdom and insight along with his co-panelists today. So with that, I'll move us to the topics up for discussion, which we've selected as a group. For each, I have prepared some questions for the panelists that I hope will steer the conversation towards the most notable and interesting aspects of each issue, and that will best capitalize on the unique experiences that our distinguished panelists bring to the table. First, we'll be discussing developments that have occurred at the EEOC as a federal agency over the past year. That includes changes in personnel, but also new directions in terms of EEOC policy and initiatives that we think are particularly significant. We'll also cover the important trends in terms of the case filings we are seeing from the EEOC, including litigation statistics that show what kinds of cases are being filed and what topics of discrimination appear to be most heavily targeted. Third, we'll provide an overview of case law developments in those areas of discrimination law that the EEOC has stated are its litigation priorities. And finally, we will talk about what may be on the horizon for 2022 and coming years in light of the significant changes at the EEOC and the interesting times that we continue to live through in this pandemic. So first, let's discuss the EEOC's lineup. Jerry, one of the most significant changes that we've seen at the EEOC in the last year is the makeup of the EEOC's commission. So, that said, can you explain for our audience what the commission is and why it's so important?
Sure. The commission is the watchdog organization, agency, empowered by federal law to enforce workplace anti-discrimination laws. And if you're an employer, you have to take account of the EEOC in terms of doing business because about 100 to 200 times a year, the EEOC files lawsuits against private sector and public sector employers, which tend to be life-changing events in the business cycle of a company. So what the EEOC says, the way the EEOC acts, what the EEOC thinks, and the manner in which the EEOC litigates is all important for employers. They're watched closely by workers, unions, plaintiffs' lawyers, and what the EEOC does is very important in terms of both regulating industries through pronouncements about its interpretations of the laws and regulating by litigation in terms of sending a message or a signal to a particular company or an industry about how the EEOC views cutting-edge issues in the law. The EEOC has 5 commissioners. Those commissioners are appointed by the president, approved by the Senate, and by law, typically is a 3-to-2 makeup of Republicans and Democrats. And when there is a Democratic president, there'll be 3 Democratic commissioners and 2 Republican commissioners. And what has occurred over the last 36 months is a transition from the Trump administration and its lineup of commissioners to the Biden administration. And so you have commissioners exiting the scene, new commissioners being nominated and coming on the scene, and basically who is a commissioner and their views of the law and workplace rights and workplace obligations are all important for employers. And so President Biden, trying to shape the government to align with his views on policies, especially labor or workplace policies, is in the process of reshaping, revamping the EEOC and its lineup. And so we saw the chair go from a Republican, Janet Dillon, to a Democrat, Charlotte Burrows. And so if one reads simply the press releases that are posted on the EEOC website, one can ascertain a change in tone, a change in position, a change in priorities as the EEOC begins to implement the Biden administration's views on what the EEOC should do and how it should regulate the workplace. As I open the session about change as the new watchword, it's certainly change in terms of who's in charge at the EEOC, what their views are in terms of what they want to accomplish, and how they are authorizing and empowering regional trial attorneys to bring litigation to effectuate those views.
And so, Jerry, we're talking about some changes to the commission this year, and I'm aware that we expect a new nominee. This particular nominee, Kalpana Kadagal, I'm also aware that you recently litigated against her as opposing counsel in the Sterling Jewelers arbitration. That said, can you tell us a bit about your experience with her and the views and policy perspectives that employers might expect?
Sure. So in the last month, President Biden, per law, per his opportunity to shape federal agencies, has nominated Kalpana to possibly become the 5th commissioner at the EEOC and to tip the balance so that there would be 3 Democratic commissioners to Republican commissioners. And as I understand it, she's now in the process of going through Senate confirmation. And so as that plays out, probably we're looking at her, assuming that she'll be confirmed, and I believe she will be confirmed, would take her seat sometime in the spring or sometime in the summer. And so in terms of what employers ought to know, here is a very gifted plaintiff's lawyer who was a member of the Cohen-Milstein firm, known for its prowess as a class action plaintiff's firm bringing cutting-edge cases. I litigated against her and the firm that was part of the largest EEOC lawsuit ever brought, happened to be in the Western District of New York. Litigated against her in private plaintiff class actions and arbitrations, and she's an incredibly intelligent, practical, passionate lawyer who I believe will do a wonderful job at the EEOC and is well qualified to take her place as a commissioner. That being said, she is passionate about worker rights, about the role of the EEOC in regulating the workplace, the importance of test litigation or litigation on the edges of statutes to push the legal envelope, to expand the rights of workers, to expand the obligations of employers, and probably using the EEOC's auspices and power and discretion over what lawsuits to bring to advance the agenda of the Biden administration in ways that would align with unions, workers, an expansive view of the protections of anti-discrimination laws in the workplace. So the fact that Democrats will have a 3-2 edge doesn't mean the votes will always be the same, but it will, in essence, clear up kind of the roadblocks where there have been only 4 commissioners, 2 and 2, and the work of the commission being stalled a bit. And one would expect once all the commissioners are in place, the EEOC will work rapidly to dispatch its business in terms of passing on new regulations or enforcement guidance memoranda, authorizing lawsuits. We'll talk about that today, that in 2022, we're apt to see more lawsuits than we saw in 2021. So it matters. Who is the new commissioner, and their view of the world matters greatly and will impact the way in which the EEOC dispatches its business.
Excellent. Well, thank you, Jerry. It's really good to have that inside knowledge, as we progress through 2022. So, in addition to following the commission's makeup, every year Seyfarth also analyzes the new cases filed by the EEOC and compares those statistics with what we now, have as a pretty vast database of information relating to EEOC litigation. So Chris, do you think you could walk us through what we are seeing in data this year?
Before we do that, why don't I hit the general counsel there at the EEOC? If you could reverse the slide, just because that's also an important note. The general counsel historically has been one of the most powerful positions at the EEOC. Not as much right now, but that might change again, and I'll explain what I mean by that. The general counsel position is currently vacant, which is not uncommon. Under some administrations, it's been open for as many as 2 years. I think that was under the Clinton administration, it was open for almost 2.5 years. The general counsel is responsible for executing on all of the litigation program that the commissioners lay out for it. Right now, the acting general counsel is Gwendolyn Reams. She has been with the EEOC for almost 50 years. She was acting, or she was an associate general counsel for almost 20 years. She was appointed as the acting GC last spring when President Biden, in a somewhat dicey political move, removed the previous general counsel, Sharon Gustafson, hard to say her name, Gustafson, from her position. And she did not go willingly or quietly, but he replaced her nonetheless. What's the difference between an acting and an actual general counsel? It's a Senate confirmed position. They have more staying power. They're expected to go through their entire 4-year term, the ouster of Sharon notwithstanding. And at least some former general counsel believe that once you're Senate confirmed, you're more likely to push the edge of the envelope. So we're going to be looking for someone to be filling that position, but there's no news on that yet. Now, one other important factor of the general counsel and why it has historically been so important is up until the Trump administration, the commission had delegated the litigation powers to the general counsel, and then the general counsel further delegated it out to the various regions. At the very end of the Trump administration, the commission pulled that power back to the commission itself, so it votes on the cases rather than delegating it to the general counsel. Jerry mentioned that there's going to be a shift in the composition later this year. We expect that there's going to be all sorts of shakeups. One of the things that might happen is this commission with the new the Democratic majority might once again delegate that power back out to the general counsel. If that happens, we're going to see the general counsel becoming once again one of the most important positions at the EEOC. That's it, Sarah. Thank you.
Great. Thanks, Chris. So then I will, move it back to you again. As I mentioned, we keep track of various data relative to the EEOC's case filings. And so I'm wondering if you could walk us through what we're seeing in data this year so far.
Sure. One of the things that most of the folks that have been on this or attending our webinar over the last 10 years have been, they're very interested in what is the EEOC up to and what can we tell from the litigation about where they are headed. And some of the data that we gather uniquely in our EEOC roundup book that we'll be talking about later is all of this data. So let's talk a little bit about that. There was a jump in the raw number of cases in the last fiscal year up to 114. That is a pretty significant jump where the previous year, the EEOC just barely cracked 100. And what's also important, we mapped this all out in the book, is there was a dramatic spike in September of last year. That's the very end of their fiscal year. Now, the EEOC would tell you that there is no spike. We don't do anything with respect to our fiscal year. However, in the last 4 weeks of their fiscal year, they filed 59 lawsuits. That was more than all of the rest of the year combined. And if you look at year over year, that spike is definitely there. So with that upward trajectory, we're still seeing in the data that we're analyzing already in 2022, we're seeing that that is a continued trend. There is an acceleration in just the raw number of lawsuits. Now, another question is, or another bit of data we can gather is, where are the cases being filed? Jerry often says this is always a question of location, location, location. And I completely agree with that. Where you are located as an employer will greatly affect the likelihood of you being sued by the EEOC. Now, some of the offices are historically more aggressive than others, but we've seen actually in the last year, there was a bit of a deviation from the usual patterns. New York, for example, which is one of the most litigious districts in the country, actually cut its cases in half. Los Angeles, San Francisco, Indianapolis, all of those regions all had dramatic downshifts in the number of cases they filed. On the other hand, Philadelphia, which, when Jerry and I first started doing these presentations, it was somewhat sleepy, but over the last several years, it has increasingly become a relevant litigation district, and we saw that last year. It had the top number of lawsuits filed. Houston's numbers doubled last year, and Chicago's filings, which Chicago is often a fairly aggressive district, tripled in the number of lawsuits that filed. So we're seeing some, not only some increases in the raw number of filings, but where they're being filed is shifting as well. The graphic that you have up right there shows you the kinds of cases that are being filed. Title VII continues to be the top statute being enforced by the EEOC, which is not a surprise given the number of protected classifications under that umbrella. But over there to the right, you can see how that breaks down, and definitely sex claims are the number one claim that the EEOC is pursuing under Title VII. It's almost 60%. You're also seeing a large number of ADA cases. And we are looking at the 2022 data, which isn't reflected in this chart just because we're only halfway through the year, but we're seeing a tremendous increase in the number of ADA claims. While the EEOC has not made a lot of noise on ADA as one of its strategic priorities, the litigation seems to be doing the talking on that front. Finally, just in terms of the impact of the litigation, in the last fiscal year, the EEOC recovered $485 million on behalf of alleged victims. Sounds like a big number, it's $500 million, right? But that's actually a pretty significant dip from the last 2 years before that. You might ask yourself, well, how does that work? You're filing way more cases, why aren't you having more recoveries? That's likely the trickle-down effect from the dramatic dip in the number of filings in 2020, and we have a lag there. But the EEOC will say that it wins 96% of its cases. Under win, it puts even favorable settlements for employers, and it's reduced its backlog by about 9.1%. So those of you seeing faster investigations, the EEOC has put a big emphasis on clearing cases. So that's all the numbers.
All right, well, thank you, Chris. So in addition to analyzing the numbers and the statistical data regarding case filings and so forth, the firm also looks into how the EEOC is pursuing its enforcement priorities and pushing developments in the law as reflected in the kinds of cases that it files and the theories of discrimination it pursues. So one of its enforcement priorities is what it refers to as the elimination of barriers to recruitment and hiring. And the theory that it has pursued most vigorously over the past few years is age discrimination. However, this year we saw a number of judicial decisions involving the EEOC's other attempts to combat discrimination, particularly against women. And Chris just kind of highlighted that for us. But Matt, turning to you, both you and Jerry have extensive experience litigating age and sex discrimination cases against the EEOC. Can you tell us a bit about the development of sex plus age discrimination claims in recent years?
Yeah, thank you. That's a really interesting topic. And for my money, when you talk about the direction of EEOC litigation, I've always found maybe not the most telling, because I think the statistics that Chris went over are really important in terms of forecasting, but in interest level, I've always found the EEOC's focus on these different strategic enforcement priorities to be the most interesting, and particularly where they are really trying to push the envelope and drive the law. And I think what you hit on, Sarah, is a perfect example. And I'm thinking in particular about a case out of the 10th Circuit. I'm going to butcher the pronunciation, but Frapide versus Affinity Gaming. And that case is not actually an EEOC case, but the EEOC did file an amicus brief. And actually, you will see that quite often in the issues that are of particular concerns to the EEOC, where they really want to drive the ball forward. They're going to start filing these amicus briefs. And in that way, it's kind of like an early warning radar detection service for employers. Like, these are the issues that you have to look forward to. Often you see first it gets filed as an amicus brief, and then it shows up as a theory underpinning EEOC litigation. So in this particular one, and it goes to your point, Sarah, it's about the confluence of age and sex discrimination. And what this case did was it recognized that intersectionality, it's the word that is used or thrown around quite often, but in this particular context, that means that there's sex discrimination, there's age discrimination, but there is also a unique and different type of discrimination that affects people who are both over the age of 40 and who may be women. In this particular case, it was the court recognized that older women in particular were facing a very unique kind of discrimination, different from just a garden variety of age, different than just gender discrimination. Why is that important? Because the age there is a separate age discrimination statute. The ADEA has its own limitations, its own parameters. But what the 10th Circuit here said was that no, you can actually bring a cognizable age discrimination claim under Title VII if it's an intersectional claim where you're mingling age and sex discrimination. Another aspect of this, and again, it's why it's so interesting in that it really is at the crux of many of the things that the EEOC has been driving forward the last few years. They relied on the Justice Gorsuch's opinion in the Bostock case, which was that landmark decision regarding LGBT rights. We'll probably be hearing about it later. But a lot of people think that the way that Justice Gorsuch approached LGBT discrimination, saying essentially that that discrimination against somebody because they are not adhering to your version of gender stereotypes is tantamount to sex discrimination, is because of sex discrimination. Some people think that the way that Justice Gorsuch defined that because of standard opens the door for a lot of different types of discrimination, including these types of intersectional claims. So I think this is one of the key issues that employers need to know about. It's on the horizon now. It's not everywhere in the case law just yet, but it's the kind of thing that with a new Democratic commission, you might see some forward progress on that. And with that, I would like to turn it around on you, Sarah, if you don't mind.
Sure.
I know that you spend a lot of time litigating sex discrimination claims as well, and you recently wrote on a discrimination theory that experienced a revival this year, and I'm thinking in particular of this case, the theory of liability in EEOC versus Stan Koch and Sons Trucking, and that's flown under the radar a little bit in recent years, but can you tell us a little bit more about this and whether you see this theory making a comeback?
Sure, Chris. So in that case, the EEOC alleged that the use of a physical abilities test had a discriminatory impact on female applicants. here being truckers, truck workers, and introduce statistical evidence to prove this theory. So according to the EEOC, defendants' use of a strength test was discriminatory because it disproportionately screened out women who were otherwise qualified for the truck driving positions with the company that they were applying to. So, you know, generally speaking, these tests are legal, or there's like nothing per se unlawful about them. But where these tests are not suited for their purpose, then courts will find them to conflict with Title VII. So like, you know, just another example, if a person was applying to a legal position and there was this test that you had to run a mile within 6 minutes, or, you know, lift 20 pounds doing bicep curls, you know what I mean, something to that effect, then a court would likely see this as having like no real relation to the job that the person is applying to, because, you know, ultimately we're sitting at our desks and, you know, doing legal analysis and whatnot. So that's sort of the general gist of, you know, the physical abilities tests and how they've come up in case law in past years. So, you know, turning back to this particular case, the district court ultimately concluded that the physical abilities test constituted disparate impact discrimination under Title VII, which prohibits facially neutral employment practices that fall more harshly on one group, so here being women, than another, and cannot be justified by business necessity. So the EEOC's efforts to eliminate potential discrimination involving pre-employment screening tests, it does have a long history. Those cases have fallen out of fashion somewhat, as Matt just mentioned, and the EEOC has focused its attention in other ways that employers allegedly erect barriers to recruitment and hiring of certain groups. That said, though, the rise of third-party firms who offer assistance to employers in making employee selections could give to a new wave of these types of lawsuits. So to that end, employers who use these types of services should be certain that the methods they use are suited for their purpose and have been properly vetted for disparate impact. So in other words, that they don't, you know, have an effect on a particular group that disadvantages them in relation to others. So, you know, with that, we'll move on to our second enforcement priority. And here I actually have a question for Chris. Another critical area of concern for the EEOC is the protection of vulnerable workers. And that's a very broad term, but in the past we have seen the EEOC interpret this priority to focus in part on migrant workers. And I know you've handled some of the biggest cases in the country involving international and immigrant labor. So to that end, do you have any thoughts as to where the EEOC could take this priority if they wanted to keep the focus on immigrant labor?
Sure, thanks, Sarah. Yeah, I think that, first of all, the EEOC takes the position that immigrant populations, whether they're in the country legally or not, are protected by federal workplace discrimination laws, and a number of courts have backed that idea, and certainly under this administration, the EEOC is going to continue to push that issue. The EEOC, when talking about vulnerable populations, the EEOC is particularly focused on those who, for whatever reasons, are either unaware of their rights or are reluctant to exercise them. There's that, Matt mentioned that concept of intersection, and this is an intersection of language barriers and discrimination, and where there's actually, in some cases, a very large power differential. So you have folks that may not even know what the policies are at a particular employer because they're not in their native language. And on the other hand, even if they did know, they would be reluctant to say anything because for whatever reason, they're very concerned because of economic disadvantage, perhaps because of the huge power differential that one reason or another, they could lose their livelihood if they say anything. So those are the areas where the EEOC has really had a laser focus, and I've had a number of those cases, and Jerry had a number of those cases all up and down the West Coast and in the Pacific Northwest, dealing with just that sort of issue, and we're still seeing the EEOC filing those cases today. A quick note, though, on vulnerable populations, we shouldn't always just think of that as that group of immigrant populations or non-English speaking populations, but it's anyone, the EEOC is interested in anyone that they feel doesn't have a voice. And one of the areas we've seen that in, for example, the hospitality industry is young women in sexual harassment cases in the restaurant space. There's, again, that power differential, that concern about saying anything. So there are a list of cases as long as my arm where they have brought suit on behalf of those victims of discrimination. So in that situation, you have to, if you're in an industry that has that kind of population, you really need to be paying close attention on both sides of what I just mentioned in terms of training and making sure you are creating those sorts of avenues for the individual workers to make complaints and feel comfortable making those complaints so that you can better insulate yourself from any EEOC activity.
Great. Thank you, Chris. So I have a question for Jerry on this front. Given your insight into the current makeup of the commission, how do you think the EEOC's focus regarding vulnerable workers might change, if at all?
I don't think it will change. Maybe the list of areas of interest may expand, and if it expands, I think it may include transgendered workers or issues on the theory that that is a group that the EEOC would consider to need its assistance and add its voice to the current dialogue about transgender rights. I also think that to the extent at any time employers viewed this priority as somewhat lip service and press release rather than the EEOC meaning it, I think the change in the makeup of the commissioners, this certainly will not be lip service. This will be super serious and significant, and I would expect that this particular priority is going to spike some major lawsuits over the next 12 months where the EEOC puts its muscle behind its priorities.
And Jerry, you know, as you know, the EEOC is always on the lookout for what it calls emerging and developing issues. It also specifically lists that as one of its enforcement priorities. So for the past few years, we've been watching the gains and inroads the EEOC has made establishing that Title VII protects against discrimination on the basis of sexual orientation and gender identity. And this, you know, culminated in the Bostock decision, where the Supreme Court specifically held that Title VII prohibits discrimination against LGBTQ employees. We also saw this past year a noticeable shift in terms of how the EEOC has been talking about LGBTQ rights since the commission changed over to Republican control. As demonstrated in the Bear Creek Bible Church decision that came out this past year, there seems to be a much greater emphasis on how those rights might conflict with employees' religious freedom. So do you think employers should expect future action from the EEOC in that regard, despite the anticipated return to a Democratic majority, or can we expect the focus to shift away from the religious freedom implications and back on LGBTQ rights?
Great question. Next slide, please. I think that the EEOC is going to focus on those issues, and employers or companies that are defending themselves are going to inject those religious freedom issues as potential defenses. And I think this is all about remembering what the EEOC's mission is. And as it has done in past Democratic administrations, it takes the view, rightly or wrongly, depending on one's politics, that the role of the EEOC is to stretch the legal envelope, that the public policy inherent in anti-discrimination laws are to create the greatest possible protection and the widest possible net of rights for workers, on the theory that people should be judged on their qualifications, experience, and capabilities, and anything else is not relevant, and any decision-making by employers with respect to protected category status is inappropriate and illegal. And so the EEOC selects test cases. It finds charges that have been brought that have compelling facts that are on the edge of interpretations of the law, and it spends a significant amount of time figuring out how can we move the law, how can we establish a new right, how can we establish an interpretation of the law that will expand worker rights, increase the obligations of employers. And so when Chris talked about location, bringing a test case in a jurisdiction where the EEOC believes there's a better potential for a judge that will see eye to eye with the way the EEOC is trying to expand the envelope. That's where we see these emerging issues being litigated. I have my personal kind of litmus test for what those emerging issues are. Besides transgender rights, I think the EEOC will be looking for a test case involving the implications of artificial intelligence used by employers in the workplace, because there's really a lack of guideposts this time. It's brand new, and whether or not use of artificial intelligence in making personnel decisions has a disparate impact on protected minority groups. I think the EEOC, in a nod to the Me Too movement, will continue to focus on the problem of systemic workplace harassment and bringing any and all cases that touch upon that issue, just because it's so important, so vital that workplaces be free of any form or variety of harassment. I think that it might be characterized as procedural, but I think there are two more issues where the EEOC will view the issues as emerging and worthy of trying to press the legal envelope. One will be a tax on private workplace arbitration agreements, and the recent law enacted by Congress, signed by President Biden, that exempts or carves out harassment issues from the scope of private arbitration workplace agreements. And so I think the EEOC is going to weigh in, and wherever there's an opportunity to attack an arbitration agreement or program used by an employer, you're going to see that on the theory that the EEOC is trying to expand the rights of workers so that they can fully effectuate their rights in federal courthouses. The other area, a little bit of a sleeper area, it's been talked about before, primarily with the Department of Labor, but it would be joint employer issues and the way in which companies operate or operate with other labor suppliers, temporary staffing services, labor agencies, and the like, where there's an argument that multiple companies, multiple employers are making personnel decisions that impact upon the rights of workers, and the EEOC trying to cast a wide net in terms of its lawsuits by bringing lawsuits against more than one company on the theory that there are multiple joint employers at issue. So I think that the EEOC's litigation of emerging issues is alive and well, and I think it will increase in 2022 due to the new makeup of the EEOC commissioners.
Mm-hmm. Thank you, Jerry. So, you know, another emerging issue is equal pay, specifically the Equal Pay Act, and it also happens to be its own, you know, well, equal pay, that is its own enforcement priority by the EEOC. So Matt, who happens to be an expert on equal pay and the Equal Pay Act, as you know, lawsuits brought under that statute have continued to be a focus of the EEOC in recent years. And I know that you've spent a lot of time thinking about equal pay litigation. And, you know, as I mentioned, it is another one of the enforcement priorities here that we want to talk about. So where do you think the EEOC is going with this issue? And what do you see as the key developments in equal pay law?
Yeah, that's a great question. I think, and this is going to sound a little too cute, but bear with me. The biggest development in equal pay law right now is that it's developing. What do I mean by that? I mean that we have seen an uptick in litigation. This chart notwithstanding, I think what this chart that you're seeing on the screen reflects the general fall off in cases that we've seen in the last few years. But both within the EEOC and outside the EEOC, there has been an uptick in equal pay litigation. And what that means is that there's more cases out there percolating through the federal courts, being interpreted. There are more substantive decisions that are driving the law forward. And that's what I mean by it's developing. And things that once seemed settled are no longer settled, or they're getting a new look, and people are making some surprising discoveries in some cases with respect to what the law means, even though it's been on the books for since 1963, so for 60 years or more. Let me give you one example of that. And this case is actually, there are two cases, and again, these are not EEOC cases, but the EEOC has filed amicus briefs on this one issue in two separate cases. That's pretty rare. That's a rare level of involvement in this one issue. It just shows you how important the EEOC is taking these this development, and the fact that now we are seeing that development. They want to get in there and start driving the law forward towards where they want it to go. The example I have in mind is it has to do with the one comparator rule, and that means that does an equal pay plaintiff may they prove a prima facie case by pointing to just one comparator? Saying that this is, for example, a female may say, here's a male doing equal work as me, but that person is paid more. That's my prima facie case. Then the burden shifts to the employer to prove a reason for that, a non-discriminatory reason for that. Well, courts have struggled with this idea. Well, is just one comparator enough? Because what if there are, yes, you are paid less than that one male, but you're paid more than another male doing equal work, or that there's a female being paid more than that male. Do you have to take that into account? And so that issue has arisen in two cases this year. One was O'Reilly versus Dougherty Systems, and the other is in the Southern District of New York. It's Eisenhower versus Culinary Institute of America, and those cases came to completely opposed conclusions. So in the O'Reilly case, which was in the Eighth Circuit, that district court surveyed Eighth Circuit law, saw that the Eighth Circuit has come to different conclusions about that as well, but concluded that if there is sort of there are other comparators out there that muddle the picture a little bit, that can be enough to defeat a prima facie case, even if there is one comparator that works and that shows that there is a person of the opposite sex doing equal work, making more money. The Southern District of New York came to a different conclusion, looking at the exact same landscape of law, but said, no, you can't really do that. And the reason is that determining whether somebody is a proper comparator is actually a fact issue, and a fact issue is an issue for the jury. So how can a court, prior to having that issue decided by a jury, decide that there are other comparators out there that muddy the waters? It's an interesting reason. It's certainly interesting reasoning. It does raise the question as to, what is the role of summary judgment then? If you're not allowed to make such issues a mere material fact, an issue in litigation at summary judgment, then what is the summary judgment standard for anymore? But anyway, it just shows you how this law is developing very quickly. The EEOC has filed amicus briefs. Both of those cases have been appealed. They've filed briefs in both, and they definitely have an interest in pushing this law forward. I'll leave it there.
Well, thank you, Matt, for that thorough insight. In relation to this same topic, many people think that sexual harassment is an issue that is closely related to equal pay, simply because both tend to relate to how women are treated in the workplace. before COVID altered our collective timeline, this issue is very much in the news with the Me Too movement, which, you know, Jerry has kind of gone over already today. But, you know, Jerry, do you see any signs that the EEOC is going to return to this issue in a big way in the coming year?
I'm not sure. EEOC has talked about equal pay for a long time, but doesn't bring the number of lawsuits that would align with how much they talk about it. But I think it is related to harassment. And one of the reasons why it's convenient for the EEOC to talk about both in the same lawsuit is harassment cases are typically very, very difficult for an employer to get dismissed on summary judgment. They're looking at going to trial. The costs are immense. And so the harassment side of the case tends to prop up the Equal Pay Act side of the case and allows the EEOC to get a better result in an equal pay issue. And so I think we're going to see a marrying of both theories and more lawsuits because it's a way the EEOC can get a more effective bang for its buck, so to speak, by bringing those lawsuits.
Mm-hmm. Makes sense. So let's turn back to the fifth enforcement priority. This one's called preserving access to the legal system. Chris, how has the EEOC demonstrated this focus so far in fiscal year 2022?
Yeah, for the most part, when we're talking about this priority, we're talking about retaliation. The EEOC has traditionally very much targeted retaliation as one of its darlings in terms of its enforcement actions. There are a huge number of lawsuits that arise under this theory, and that should be no surprise because the largest single category of administrative charges that are filed are retaliation charges. And for those of us that try these cases, these are the ones that are very dangerous because a jury or a judge may not bite on the underlying theory of harassment or discrimination, but retaliation claims that can be sometimes sustained merely on timing alone are very difficult to defend. So there's something that employers, number one, need to be concerned with regardless of the EEOC, but when you have the EEOC also very much interested in it, in the budget request for 2023, Chair Burrows said that this is going to be a big part of the platform for the next year. They're having a joint task force with the NLRB and the Department of Labor to consolidate their enforcement on these issues. So retaliation is something that if you're not paying a whole lot of attention to it, you should be doing a lot of training around this space, making sure that your policies are up to date and you're getting that out. Just as a side note, another area underneath this preserving access is what the EEOC believes are unlawful releases. We don't see a whole lot of litigation activity around that, but I still would advise employers make sure that you have a state-of-the-art release because the EEOC is every once in a while, I'd say once every 2 or 3 years, it picks a big case to make a point that you can't keep somebody, for example, from filing a charge. You can't prevent somebody from participating in an EEOC investigation, but there are a lot of old language releases floating around out there, so they find these targets.
Thank you, Chris. And with that, I'll just turn us to the CLE code for all viewers who wish to obtain CLE credit for today's webinar. The code is SS1282. Again, that's SS1282. So we've talked a lot today about changes at the EEOC that we've seen over the past few years. Now let's switch gears a little and talk about what employers should expect to see in the year ahead. Matt, can you kick things off for us? What do you see as the top 3 issues that you think will drive EEOC enforcement activity over the next 12 months?
Great question. I think I'm going to have to echo a lot of the things that have already been said. I think equal pay, that seems to be on the EEOC's radar in a big way. Maybe we'll see some more movement there. I think the AI issues that Jerry mentioned, not just AI, but big data, it's basically the employer's use of technology to recruit and select employees. There is not a lot of guidance out there on that, and it's becoming increasingly important. And then I think I'm kind of torn between the sexual harassment issues, which are a big one, and also LGBT issues. LGBT issues have reigned supreme over the last decade or so. And with the Bostock decision, I guess I'd have to give the nod to LGBT issues. I think the Bostock decision and what's going to happen in the wake of that, and how the parameters of LGBT issues will be defined by the EEOC, is going to be a big, important issue.
Mm-hmm. And Chris, I know that you have some visibility and insight into how the Commission's been voting recently. Is there anything you can share with us about what those voting trends tell us about the direction that the EEOC may be heading?
Yeah, so with the changing composition, you might say, well, this is old news, but really it shows a trajectory here. We're able to see all of the EEOC votes. Interestingly, when it switched over to a Republican commission, a lot of employee rights groups figured, oh, well, that's it. There's not going to be a whole lot of cases filed. It's turned out not to be the case in the last year. Almost 2/3 of the cases up for vote have been approved. Half of them have been unanimous among the commissioners. So the commissioner is still greenlighting, commission is still greenlighting a lot of cases, and the vast majority of systemic cases have been approved. Now, Democrat commissioners Burrows and Samuels have always, virtually always, voted in favor of the litigation, whereas the outgoing commissioner and former chair Dillon has voted to disapprove a whole lot of significant cases, with the others, Sonderling and Lucas, falling in between. Once it shifts over to a full Democrat majority, I think we're only going to see an acceleration in the number of cases. Mm-hmm. And Sarah, real quick, before we move on, I'm noticing that lots of people didn't catch the CLE code. So before we wrap for the day, let's read that off one more time.
Sure. The code is SS1282. Again, it's SS1282.
Thanks, Sarah. Sorry to interrupt your flow there.
No worries. So I will turn the floor back over to Jerry. You've handled more EEOC litigation than all of us combined, and in fact, more than anyone I can really think of. So can you give our listeners the benefit of your experience in terms of your thoughts for how employers can stay out of the EEOC's crosshairs?
Sure. I think there are three things that if I ran a company, I'd be thinking about at night in terms of what the EEOC is looking at. And I think those three things are: first, how do you pay people? Second, how do you promote people? And third, what sort of work environment you have. And basically, the way you pay is self-evident. The way you promote is about your employment opportunities, and your work environment is what sort of office, plant, whatever environment you have to stamp out, prevent workplace harassment. So I think in terms of how do I keep myself off the radar screen of the EEOC, I don't think any employer wakes up every morning and says, what employee am I going to discriminate against today? Rather, problem employees or employees with problems stem litigation or EEOC charges. So I think the best possible heat shield, the best possible risk mitigation protocols are a really robust human resource department, state-of-the-art policies, but it's how those policies are enforced, utilized, and administered. So when an employee has a problem, the HR folks need to jump on it, investigate it, remediate it, take care of it, because remember, these are issues that an employer can take care of within its own house before an employee thinks that no one's listening to them and the only way they can get some workplace due process is to walk down the street, visit the EEOC, and have the EEOC file a charge on their behalf and to start an investigation of that workplace. So I think that having the best possible set of HR policies and the best trained and implemented HR professionals carrying out those policies is the #1 defensive mechanism to prevent any of these problems involving staying off the EEOC's radar. So I think we've got to the bewitching hour, and we want to be respectful of your time. This is the book we were talking about that we publish every year. You can get it for free, download it or as an ebook or a paper book off www.workplaceclassaction.com, the website that our practice group has and disseminates. We have daily updates that are there. This would analyze all the trends, cases we've talked about. It's been referred to in various media outlets, including the Wall Street Journal. And so we're hopeful that you'll subscribe to our website and to our books. So on behalf of all of our speakers, I wanted to thank all of our attendees for spending time with us and hope you have a wonderful afternoon. Thank you so very much.
Thanks, everybody.